We begin here. Former President Jacob Zuma is not in court today while his lawyers are applying for yet another postponement. According to the Jacob Zuma Foundation, the former president is not well and his doctors have advised him not to attend court. Meanwhile, the National Prosecuting Authority says it's ready to proceed with the corruption trial and accuse the former president of employing delaying tactics once again. My colleague Tulasizo Simalane is in the High Court in Pietermaritzburg where that case is being heard. He joins me now for an update. Tulas, I think what I found interesting, of course, is the fact that the state is concerned that if this application is granted, it would basically open doors for the former president to keep applying for more petitions and postponements, which means he might actually even avoid going on trial.
Yeah, absolutely. Those were the arguments of Advocate Billy Downer, who basically says the latest bid by the defense and Mr. Zuma is made in bad faith, and that is yet another delaying tactic, part of the Stalingrad approach that they've been employing in this particular proceedings, and basically urging the court to not accept Mr. Zuma's application for a postponement. This, of course, comes, Masego, I've got to say, that we earlier on were talking about this, as from yesterday actually, here on eNCA, that Mr. Zuma's application today and his approach to the Supreme Court of Appeal president is premised on Section 17(2)(f) of the Superior Courts Act. And indeed, it turned out to be that way, in that this is, a reconsideration application, as Judge Pitkun is, phrasing it, that it's a reconsideration application. Much turned in the debates that have been happening in the last few hours on, while there's this application to the President of the Supreme Court to consider whether there are exceptional circumstances that warrant that she should take this decision of those two judges of the Supreme Court of Appeal, send it back to the court for them to reconsider and, if possible, vary their order that says that Mr. Zuma will not be heard by that court because his matter has no reasonable prospects of success. While that is pending the decision of the President of the Supreme Court, what becomes of these proceedings, the criminal proceedings? And I think that's been the nub of it. What is the effect of the fact that this, the dismissal of the special plea by Mr. Zuma for the removal of Prosecutor Downer is now a matter that stands before the President of the Supreme Court of Appeal? What does it mean for these proceedings? Does Judge Pitkun insist that we go ahead and forge ahead, which is what the NPA is arguing for, to say enough delays, this is abuse of process, it's part of the Stalingrad approach, which of course Advocate Dalimpofu pushed back vehemently against, to say that actually there is no Stalingrad approach here. Mr. Zuma has at every turn since these proceedings started done everything to ensure that these proceedings actually go ahead. He is making the timeline, of course, Masego, to be one that runs from the announcement in 2018 that Mr. Zuma would be charged with these 16 charges. That is the timeline that Advocate Dalimpofu is concerning himself with. He says the argument that says it's nearly 20 years is neither here nor there, because these particular proceedings have only been on the go since 2018, since that decision was taken, and at every turn, according to Mr. Mpofu, former President Jacob Zuma has availed himself and facilitated that these proceedings should move ahead, including waiving his rights previously, the right to be present in court when his matter is being heard, when it's a criminal matter, because there is that right. And Advocate Mpofu saying that he's done that yet again today, to say, while I have a right to be in court while the matter is being heard, I will actually waive that right so that I don't hold up that process. So interesting start to the arguments. We are now adjourned until 2 p.m. To hear from Judge Pitkun, who will be reflecting on those arguments.
All right, Tilasizo, let's bring our other colleague, senior reporter Siphamandla Goke, who in fact is with you there. Sipa, I'm interested to know more details about that impromptu press briefing where the Jacob Zuma Foundation let us know that the former president would not be in court today.
Indeed. So before we could start with the court proceedings around 10 o'clock, Jimmy Manyo, should I say, Mr. Mzwanele Manye, who speaks on behalf of the Jacob Zuma Foundation, called an impromptu media briefing where he briefed the media that the former president is unwell. His doctors have advised him not to attend today's court proceedings, saying the matter is being dealt with and his doctors are monitoring him. Of course, he said it was a last-minute thing. That's why when we came here earlier on, we saw the security detail of the former president. Members of the Presidential Protection Unit are still here in the corridors of the Pietermaritzburg High Court because we were expecting the former president to attend today's proceedings. Even Advocate Dalimpofu, senior counsel, arguing in court, telling the court that it's an emergency and it's being attended to by the doctors. But nonetheless, he confirmed to court that he did receive instructions to proceed without the former president because there has been arguments and counter-arguments, finger-pointing exercise and blame game between both parties, the state and the defense. The state is adamant that these are time-delaying tactics. On the other side, Advocate Dalimpofu saying, well, that is not the case. Advocate Billy Downer, the state lead prosecutor, arguing very strongly that the court should not entertain this application by the defense team whereby they are seeking a postponement pending the finalization of that matter that they have sent to the Judge President of the Supreme Court of Appeal, that is Judge Mandisa Maya, whereby they want her to look at their application following the dismissal by the two judges of the Supreme Court of Appeal of the matter that the former president had indicated to take to the Supreme Court of Appeal, to petition them to listen to him after he failed to persuade Judge Beth Kun here to reconsider his decision to deny him. So that was the argument inside court, the state arguing that the former president is employing time-delaying tactics. Judge Beth Kun saying, well, hang on, there is legal recourse. The law allows him to come up with these applications, frustrating as it is, but it is there provided in the law. On the other side, here, Advocate Dalimpofu saying, we have always been ready to commence with this trial. We are not employing time-delaying tactics, dismissing the allegation that they are employing a Stalingrad approach of delaying and appealing every time. Let's take a listen to Advocate Dalimpofu arguing that they are not wasting time.
Your Lordship will notice that the first accused is not in court. There was a medical emergency which took place in the past few hours, and we have been liaising with the doctors. The situation is being attended to. I've now, since we spoke to you, my Lord, been assured that we might get some kind of document later in the day. But be that as it may, the proposal that we had discussed in chambers was the possibility of being able to proceed in the absence of the first accused. And obviously, as I indicated to Your Lordship, I had to get instructions in that regard. I'm happy to announce, my Lord, that I have since received those instructions.
Well, Siphamandla, I think for me, what was also interesting is towards the end there, where Advocate Dalimpofu felt very insulted by what Prosecutor Billy Downer called baseless petition. He also looked at, I think there were all semantics, I guess, about petitions or a petition, plural or not. Can you just explain to us what the argument was there? What was the issue with that?
I think we need to brace ourselves for these interactions between the state and the defense. They will continue. There is too much mistrust between the two parties here. Advocate Dalimpofu is of the view that the attitude of state lead prosecutor Advocate Billy Downer was not in order, dismissing their applications and the arguments that they were making. He viewed that in a negative light to say, well, it doesn't augur well for the professional conduct, and also the fact that according to Advocate Dalimpofu, Advocate Billy Downer was so dismissive and condescending in his his tone and attitude, and that is something that he took exception with. So that will continue to be the case as this trial continues, because the two parties here appear not to trust each other, and at times you do get these outbursts. I can't recall of a situation whereby there was this court case and there was no heated exchange of words between the two parties. It has been going on, and it appears that it will continue to go on as both of them feel strongly about their arguments during the court proceedings, Masego. And if we can take a listen to what Advocate Billy Downer had to say about, the application to postpone this matter when he was persuading the court and Judge Pitkun not to entertain it, saying it's part of time-wasting tactics. Let's take a listen.
And might I just also say up front that my learned friend has conceded a concession if mala fides were to exist. In other words, were this court to be of the opinion, and this is the state submission, that indeed this application which currently is before this court is mala fides in the sense that it is part of the Stalingrad defense and is meritless and is but one of those defenses which is raised continually without any prospects of success, knowing by any proper reading of the law, and is nevertheless proceeded with. So it's done in bad faith. It's done to delay in that sense, and we make this submission very seriously at this stage.
All right, Thulasizwe, let me come back to you. In terms of Section 17.2F, I think they spoke of, and you also spoke about it, of the Superior Court Act. Can you just help me and other viewers who might not be understanding in layman's terms? Of course, we've seen the former president go to a lot of courts to try and avoid, as the state would say, finally going on trial. So can you just explain to us a little bit more the argument around this particular act?
Sure, absolutely, Masego. It's a bit convoluted in terms of how it's written, as many of these pieces of legislation often are, because, when they are writing this legislation, it should withstand whatever challenge may come and be flexible enough. So they try and write it in a language that is not circumstance too specific, but, such that it encompasses enough permutations that may arise from time to time. But in essence, it basically says the decision of the majority of judges, and this has to do with appeals, is final. So the decision of the majority of judges, if the judges are sitting as a panel of judges, 2, 3, 5, that decision is final, and then goes on to provide that, under exceptional circumstances, the President of the Supreme Court of Appeal may, if there are those exceptional circumstances, either of his or her own accord, or based on an application that is brought within a month. So that's also the other important factor here, Masego. Within a month of that decision having been made by the court, remit, that means send back that issue to the court for reconsideration, or if necessary for variation. But these circumstances have to be exceptional, because the court wants there to be finality. They don't want a situation where there's a revolving door of appealing against the finding of the Supreme Court of Appeal, and you never really get to move forward. One of the other interesting aspects, though, coming through from Judge Pitkun from the bench in his interactions with Advocate Dalimpofu, was the question where he said, for me to decide how to proceed from here, what the implications are of you having approached the President of the Supreme Court of Appeal. For me to make that decision, it means I need to also apply my mind to what it is that you've placed before the President of the Supreme Court of Appeal. And that means necessarily for me to look at the strength of your arguments for her to, remit that matter back to the Supreme Court of Appeal for reconsideration. And for me to do that, it really takes me back to issues that I've already made a finding on, to say there are no reasonable prospects of success on appeal against that initial special plea being dismissed in this court. So it gets convoluted, but the essence of it, Masego, exceptional circumstances. The courts don't like their processes becoming a revolving door of appeals, and also the other issue is Judge Piet Koen has been asking legal teams here that is it desirable for me to be asked to make decisions on the go, and those decisions are appealed, or should we park all of the interlocutory processes where you are aggrieved until at the end, when there's final judgment on this matter? If and when you feel you need to appeal, you then bring everything and you appeal at that particular stage. And those are some of the questions where he's been saying to the legal teams, guide me. What are you saying now about that we want processes to move and get to the end, and then you have a consolidated appeal that appeals everything that happened within a trial?
All right, Tulasizo Simelane, eNCA anchor, thank you very much for that update. We'll come back to you a little later on. Earlier, we also had senior reporter Siphamandla Koke. Let's take you